the Division of Human Rights officially adopted regulations that includes discrimination based upon gender identity within the definition of sex discrimination. And these regulations were initially proposed in October of last year, but became finalized and are in effect as of today. So we're going to talk about these new regulations first, since they are incumbent upon us all to comply with on a go-forward basis. So these regulations are codified at 9 NYCRR 466.13, and they address gender identity, transgendered persons, and gender dysphoria. And essentially what the regulations do is they incorporate gender identity, transgender individuals, and gender dysphoria into the law that has already existed that prohibits discrimination. So you cannot discriminate against employees based upon gender identity or status as a transgender person. That's considered sex discrimination now. Harassment based upon gender identity and being a transgendered person is considered sexual harassment. So we'll all want to update our policies to make sure that these terms are included in our harassment and discrimination policies. Excuse me. And also, sorry everyone, I've had a cold for the last couple of days. Also, a discrimination based upon gender dysphoria is a medical condition, is explicitly incorporated into the definition of disability discrimination. And just so that you have an idea of what these terms mean, gender identity means having or being perceived as having a gender identity, self-image, appearance, behavior, or expression, whether or not that gender identity, etc., is different from that traditionally associated with the sex assigned to that person at birth. So, in as much as these regulations are meant to focus on transgendered persons, gender identity applies to us all. I have a gender identity, it's female, and it happens to be the identity that I was born with. So it would be potentially possible for someone to raise a gender identity discrimination complaint even though they present as the gender that they were born with. A transgendered person is an individual who has a gender identity different from the sex assigned to that person at birth. And gender dysphoria, as I mentioned, is a recognized medical condition related to the individual having a gender identity different from their sex assigned at birth. So what does this human rights law now prohibit? It prohibits discrimination in employment based upon gender identity and against transgendered individuals. And all of the same rules that apply to prohibition of discrimination in employment to other protected categories, such as race, religion, ethnicity, national origin, would apply to transgendered individuals.
No, that should actually go to our IT department.
Guys, I can hear you.
I can give you the number. It's 315-218-86.
Also,
okay. You're so welcome. Bye-bye.
Medical conditions, which, so those seeking treatment for gender dysphoria would have to be accommodated. It prohibits discrimination by places of public accommodation against individuals with that have a transgendered identity or based upon their gender identity. So you cannot refuse to provide services to an individual based on their transgendered status, for example. It prohibits discrimination in housing. So if you have municipal housing or nursing home housing or other places of publicly provided housing, you cannot discriminate against a transgendered individual or an individual based upon their gender identity. What the law does not do, which other laws in other states and other areas of this state have done is it doesn't set specific requirements or guidelines for how to address the practical issues related to individuals with different gender identities or have transgender status as they're going to rise. There are trends in this area, and these trends have grown quickly and snowballed very quickly. This began, I would say, in about 2012 when the EEOC issued a strategic enforcement plan. And while gender identity, transgender status is not within Title VII enforced by the EEOC, in 2012 the EEOC decided that it would include that type of discrimination and sexual orientation discrimination under sex discrimination prohibited by Title VII. And the EEOC has issued guidance on this that came out, and this is the guidance that was issued if individuals are interested in seeing that. And as you can see, the number of complaints have gone up over the years. This is a little bit misleading. This is only a 6-month figure, so if you multiply that out, this would be more about like 1,200 complaints. But over the years that they have been tracking and considering transgendered status as a protected category, these complaints have risen with the EEOC. So you should pay very much attention to that as we go forward, both under the federal and now under the state law. 2 years later, in July of 2014, there was a presidential executive order which added gender identity to protected categories for federal procurement contracts. And as of today, now that New York has protections in its law, there are 18 states in Washington, D.C. that have laws that protect gender identity. And that may be 19 because Massachusetts had also proposed laws that would protect gender identity, which may have been enacted since the end of 2015. And there is a lot of enforcement activity in this area, which is one of the reasons why we thought it was important to do this webinar. I mean, just yesterday, the EEOC settled a case with a Minnesota company for $115,000 plus another $40,000 in attorney's fees that was based upon transgender discrimination. Basically, the EEOC found that the employee wasn't allowed to use the women's restroom, that she was called names and epithets were used against her. Her preferred pronoun was not being used by employees, and therefore she was subject to a hostile work environment and employment discrimination. Last year, in April, there was a $150,000 settlement with the EEOC against an eye clinic for similar complaints when a transgendered woman was terminated after she transitioned during her employment from male to female, and customers complained that they did not want to be around her, and she was terminated. So what do we do? The regulations that the state has passed have not given us a lot of guidance with regards to the specific issues that we're likely to face. The big ones: what restrooms, what do we do about restrooms, what do we do about other customers that might complain, or other individuals that are using our services might complain, or other employees that feel uncomfortable with the situations. So although there are no guidance under the state statute, New York City has had a similar protections in effect since 2002 and has developed very specific guidelines. And we will send you a copy of this document after the presentation. But this document, although it's not you're not required to follow it because it applies to only New York City companies, unless you are in the boundaries of New York City, actually is a very good guidance document for any employer or public accommodation that is looking to try to comply with the law in a way that's reasonable. And it follows the trends of other municipalities and states that have, and agencies that have enforced the law. So what is it that New York City specifically requires? First, you cannot require a transgendered individual to use the restroom of their biological sex. So if a transgendered individual presents as a woman, they have to be allowed to use the ladies' room. You can't require them to use the men's room. And you can't require them to use an exclusive bathroom either. They may if they wish to do so. So if you have your traditional multi-person ladies' room, and then you have a separate room that's an individual restroom, the transgendered person can use that restroom if they want to, but you can't force them to use it if they don't. You can't require an individual to provide medical documentation or other proof of a physical transition. So you can't require that they be post-operative in order to assume that they're transgendered. And a lot of the guidance on this relates to the fact that many transgendered people can't afford to go through the operation or procedures that are required, or maybe in other stages of their gender identity. And just because they haven't gone through the surgery does not mean that they don't identify with the gender that they identify with. It's also unlawful not to use the individual's preferred name and pronoun regardless of their biological sex. Now this is codified in the New York City ordinances and local laws, but the trend in case law that's related to harassment and discrimination against transgendered individuals, that is a big component of findings of discrimination and harassment, is that supervisors and co-workers tend to use the non-preferred pronoun and the transgendered individual's birth name instead of their identified gender name and the pronoun applicable to their identified gender. Also, in relationship to both employment and public accommodations, you can't refuse to allow an individual to participate in the program or activity based upon their biological gender if they identify with the other gender. So if you have a program that's only open to women or girls, or a program that's only open to boys and men, if a transgendered female, meaning that they're biologically male at birth, wants to participate in the girls' basketball team, for example, they have to be allowed to participate in the girls' basketball team. Also, under the New York law, and this is an area that may differ significantly in the implementation of the law across the state, because it is different in enforcement in other areas, is that you can't have gender-specific dress codes in New York City. So you couldn't have a dress code, for example, that would require women to wear skirts and men to wear pants. And again, this is an area where there is significant disagreement in other jurisdictions that have gender identity protection. And it's also something that has been upheld in federal law for typical identifying individuals that do identify with their birth gender, that you can have these types of dress codes. But what I would say is that you couldn't do, likely under the new regulations, is that if I were a gender identified biological male identifying as a female, you couldn't make me follow the male dress code. You would have to allow me to follow the dress code that is applicable to the female employees. And again, another area, the Federal Office of Personnel Management, which is the federal agency that is basically the HR for the federal government, has issued guidance related to transgendered employees, and the link is there. But under the federal guidance for the Office of Personnel Management, it's very similar to the guidance that is in New York City and in other jurisdictions. And again, I put this here not because this is binding on any of us at this point, but because it provides us with a path to compliance and making sure that we don't step on any landmines in this new area of law through tested waters. The federal OPM guidelines have been up for a significant period of time. New York City has had its rules in effect, obviously, since 2002. So we can look to those places to try to help us navigate these new waters. So in order to think about what steps we should take and how this might affect us, let's work through some hypothetical. So Jason has worked for a manufacturing company for 10 years. He's always been a good worker, good attendance, no disciplinary record. He's a great employee. One day, Jason asked to meet with his HR manager, Donna, and he informed her that he's going through gender transition. He says he's been dressing at home for months, and he wants to start, he's going through therapy, and wants to start presenting as a woman at work, and plans to start in a few weeks. And, you know, good for Jason for bringing this up ahead of time. And Jason is now referred to as her. That's his preferred pronoun, corresponding to her gender identity as female. And this is typical of an issue that might arise for any of us. I mean, as a public accommodation, if a transgendered individual comes into the door to use services one day, it may not be, or most likely won't be, that obvious that that person is transgendered because you don't know them, you haven't spent time with them, you've only seen them on a one-time basis. Or we may all have transgendered individuals around us that we don't know are transgendered because they've always presented as one gender to us and we haven't asked. But this is a typical scenario where you have someone who has presented as one gender to the community, with the work community, or the public accommodation community for a significant period of time, and now wants to undergo a change that would be noticeable to those around them. So Jason asks to have all her employment records changed to reflect her new name, which she wants to go to by Janet. She wants a new company ID badge with a new picture and name, and she wants to begin using the female restroom. So we are in a very traditional manufacturing environment in the conservative community, and you can substitute very traditional manufacturing for very traditional any other kind of environment in a conservative community where issues might arise. Our Donna, our HR person, is very concerned about employees' reactions. She'd like to issue a memo to all employees. She considers conducting training. The plant manager, Todd, says he just wants to keep it quiet, doesn't want to draw attention. He thinks it'll just make it worse. Initially, our HR person communicates nothing and leaves it up to Janet to tell others if they have questions, and she just says talk to Janet or Jason. So after Janet begins using the female restroom, another employee complains that she does not feel comfortable sharing the restroom with a man. And this is going to be likely when the first time that you address this issue, it will likely be, this will come to the forefront. Janet later asks for FMLA leave for reassignment surgery. And we want to know what happens if it's for hormone therapy or other psychological counseling. So what's our best practice? And we've talked about this in an earlier slide based upon what other jurisdictions have been doing. The best practice is to allow the employee to use the restroom that corresponds to his or her gender presentation and not to the biological gender. And as we discussed in New York City, it's against the law to require them to use the restroom of their biological gender. But in many other cases that have arisen in the last couple of years, the requirement that a transgendered employee use a restroom of their biological gender or a separate restroom that's not open to all employees of the same gender has been considered part of the evidence of discrimination against that individual. And there may be some future trends as far as how restrooms are built and developed to try to address issues that come along with these types of things. But right now, if you have a ladies' room and a restroom in your facilities, the transgendered employee or individual, in the case of a public accommodation, should be allowed to use the restroom of identity. What do we do about other employees or individuals who complain? And this is a big issue. We feel that we're affecting those people's rights just as much as we may be affecting the rights of the transgendered individuals. Our recommendation is that if there's another restroom available for the complaining employee, that you allow that employee to use the other restroom, rather than forcing the transgender employee to do to go to the out-of-the-way restroom or the individual restroom. And there is precedent, not in this state, but in Minnesota, for an employee who complained about a transgender coworker who was using the restroom. And this employee said that it violated her religious rights and her rights as a female employee to have to use the restroom, and the biological male was present in the restroom. And the court dismissed the complaint. The court said that there wasn't any adverse employment action and there wasn't a hostile work environment for the non-transgendered employee who was uncomfortable using the bathroom with a transgendered employee. So what about communicating information to the rest of your employees, or to the audience that you are that you will be in front of, whether it be as public accommodation or as an employer? So as we said before, Donna wanted to have some kind of communication plan. The plant manager did not. He wanted to keep it quiet. We would say that Donna's instincts are good to want to address the issue up front, and the plant managers were not so good. Especially if there's a concern of backlash, you want a clear message of support that indicates that there's, that this person should be treated with respect and no differently than any other employee, even though there has been some change. And usually some kind of explanation will help resolve a lot of tension that might occur when Jason is all of a sudden in the bathroom with all the other women, and they weren't expecting that. So you can start with a positive tone. So it's recommended that if you have an employee or a resident or other individual that's known to the rest of your community or workforce, that's transitioning to talk about having a communication plan and how you might roll that out. If Janet doesn't want to have any kind of communication and she's the one that wants to keep it quiet, then that's something that that you have to respect. But generally speaking, in these situations, individuals want to try to transition as smoothly as they possibly can, and talking about it somewhat helps that. And you don't need to notify everyone. Only those who work or are closely aligned with the individual, in this case Janet, would need to have be part of that communication plan. As always, you need to keep medical information confidential, and you want to make sure, again, that you respect the privacy of the transgendered individual as much as they wish to have it kept confidential. Also, as a proactive measure, maybe even before you have a transgendered person in your midst, updating your harassment and diversity training will also go a long ways towards quieting and quelling rumors. It puts potential harassers on notice and sets a tone of respectfulness. You know, you have a legal obligation to maintain a harassment-free environment, which actually does extend to transgender employees now, and did by relation under the EEOC's enforcement guidance previously. And I think that this is an area, in reading a lot of the cases that have come up related to transgender issues, it seems that this is an area where people have felt that it was okay to continue to be less respectful in the work, even in the workplace and in other places, because it's so new to most of us. And so this is an area where I would recommend that we would want to have proactive policies, proactive training, because I don't know that everyone out there is acclimated to the idea that you're not supposed to be disrespectful or say certain things to transgender individuals, as they would be acclimated to knowing that you can't make racist comments against people because of their different race. So name change issues, employers are going to go through this. They're not unique to transgendered employees. People change their names all of the time. So, you know, Jan's request for a name change should be responded to the same as any other request for a name change. Again, in under the New York City guidance, you're not allowed to ask for a legal name change. You have to use their preferred name. Also, how you're going to look at that name change is going to depend on which part of your company's record keeping and documentation that you're going to be addressing. So obviously, it's easy enough to call an individual by their preferred name. I mean, calling Jason Janet wouldn't be any different from calling Michael Mike. It's just a preferred name of reference. And you shouldn't need a proof of legal name change to do that. Similar with an ID badge. I mean, unless you're in a highly secured environment, that there's some other aspect of why an ID badge needs to be more secure. But a typical employee ID badge, you know, you can put their nickname or their preferred name on the badge so that people can see that. And I would say that I know some companies have ID badges where you have the nickname up at the top, but then the full legal name is at the bottom. In that situation, I would strongly recommend against putting the birth gender, full legal name at the bottom, because that would identify that person as a transgendered individual based on the differences in the name on the ID badge. So you want to think about that when looking at these issues. And a lot of these systems may be automatic. It's not something that necessarily comes up that frequently, but make sure that your automatic system, so for example, a lot of companies, your email address is your first name with a period and your last name or some combination thereof, and you may need to make a special exception to try to change the email address for the transgendered individual so that their email address doesn't highlight the fact that they happen to be transgendered because they're going by a different name and different gendered name personally, and then it's on their email. So what about their paycheck? So this would require to change someone's name on their paycheck would require a name change, because your W-2 and W-4 forms have to match your Social Security card, and therefore an employee would have to have a Social Security card in their preferred name if they wanted you to change their payroll status. But you want to make sure, again, that if there's somebody else that wants their payroll status changed, that they also have to bring a new Social Security card with their new name. For example, if somebody gets married and wants to change their last name, don't just go through and change everything without requiring that Social Security card change if you're going to require that of the transgendered people, which you should do also anyway. Health benefits. Changing to health benefit documentation should reflect the employee's legal name. So we don't recommend at this point to change them because obviously there are tax issues involved with the health benefits and other legal issues involved with the health benefits. So they should reflect the actual legal name. You may question about whether you need to fill out a new I-9. You do not. The Immigration Department, which is USCIS, now does recommend that you make a change to the Section 3 of the I-9 if there's a name change, if there is a legal name change. And again, be consistent with what you require for these changes. Don't just require them of transgendered individuals. FMLA, this was brought up in our hypothetical. Certainly under FMLA, a sex reassignment surgery would be a serious health condition. It requires overnight stay in the hospital. I mean, remember, through training and just knowledge, try to avoid thinking about, some people may, again, because they're not educated in this area, may consider treatment and therapy related to gender transition as similar to being a cosmetic surgery or other types of surgery that wouldn't necessarily bring FMLA protection. This isn't cosmetic surgery, it is a real need. So we want to make sure that we're following all of the legal requirements, obviously sex reassignment surgery. And I would say that hormone therapy or psychological counseling, especially when they're associated with gender dysphoria, which is a diagnosed medical condition, could qualify for FMLA leave and does have to be accommodated now under the New York State Division of Human Rights regulations. So if they need to take time off from work to go get the therapy treatments or to go to see the psychologist, that would be something that you would have to accommodate if you reasonably could. Dress codes, we talked about this a little earlier. Generally, gender-specific dress codes or grooming standards are lawful outside of New York City and New York State. Again, this may create issues when transgender employees wish to follow the dress codes corresponding to their gender identity. It is highly recommended that you allow a transgendered, if you have gender-specific dress codes, that the transgendered individual be allowed to follow the dress code that's related to their specific identity, not to their biological gender. Although it's not specifically set forth in the regulations. So let's move away from some employment issues and talk about public accommodations and other municipal services. First, and this is probably the easiest part of the statute to identify, places of public accommodations. The provision of services, you can't discriminate based upon gender identity or transgendered status. So you couldn't, just like you wouldn't be able to refuse service to somebody based upon their race, or not allow them to participate in an activity based upon their race, you can't discriminate against them because they happen to be transgendered. I wouldn't be surprised if 8 or 9 times out of 10 you wouldn't necessarily know someone was transgendered, but you may be able to identify that, and you can't discriminate. So what's a place of public accommodation? And the human rights law is very specific about this, and it means all places included in the meaning of such terms as inns, taverns, roadhouses, hotels, motels, whether conducted for entertainment of transient guests or for the accommodation of those seeking health, recreation, or rest, restaurants or eating houses, or any place where food is sold for consumption on the premises. Buffets, saloons, bar rooms, or any store, park, or enclosure where spirituous or malt liquors are sold. Ice cream parlors, confectionery, soda fountains, and all stores for ice cream, ice, and fruit preparations, or their derivatives, or where beverages of any kind are retailed for consumption on the premises. Wholesale and retail stores and establishments dealing with goods or services of any kind, dispensaries, clinics, hospitals, bathhouses, swimming pools, laundries, and all other cleaning establishments, barbershops, beauty parlors, theaters, motion picture houses, aerodromes, roof gardens, music halls, race courses, skating rinks, amusement and recreation parks, trailer camps, resort camps, fairs, bowling alleys, golf courses, gymnasiums, shooting galleries, billiard and pool parlors, garages, all public conveyances operated on land or water or in the air, as well as stations and terminals thereof, travel or tour advisory services, agencies or bureaus, public halls, and public elevators of buildings and structures occupied by 2 or more tenants or by the owner. Such terms shall not include public libraries, kindergartens, primary and secondary schools, high schools, academies, colleges, and universities, and all educational institutions under the supervision of the Board of Regents. Now, and that's because those public entities, schools, are covered by other laws. But so if your municipality, then any of those things that you run or similar areas that you run are going to be covered by as a place of public accommodation and have to be cognizant of the fact that you can't discriminate against transgendered individuals. And that means training your employees to remember to be respectful when transgendered individuals might come into the establishment. Again, it's not common for many of us to see transgendered individuals, and if it's obvious to us that somebody is transgendered, some people may not know how to react. So I think that training in this situation is a very good idea, and you don't have to have specific transgender training, but you incorporate that into any other public service type of training or anti-harassment training that you might have. So what other services might be related to our municipal governments that are out there where transgendered individuals could become problematic or create a conflict between non-transgendered individuals and the transgendered individuals. And one area specifically are nursing home facilities. And it's interesting, you know, in doing the research to put this webinar together, there are lots of, at any situation that you could think of a transgendered individual being in, there is, you know, a half a dozen or a dozen websites that pop up that inform those individuals on what their rights are and what they can do about that. So there are definitely very strong advocacy groups to try to help transgendered individuals navigate through life, definitely. So for nursing home facilities, I know many counties and municipalities have public nursing home facilities. Now, there's no specific law that says that a nursing home facility cannot discriminate against a transgendered individual. However, the human rights law now prevents discrimination in housing. A nursing home facility, it can be considered housing, and therefore a transgendered person could not be prohibited from residing in a nursing home, for example, because of that. However, there's also the Federal Nursing Home Reform Act, which requires nursing homes to protect and promote the rights of each resident, and also to maintain residents' highest practicable physical, mental, and psychological health. So with that in mind, you know, any situation that might occur or harassment that might occur in a facility by other residents or by staff would violate those provisions of the Federal Nursing Home Reform Act. Also, the Federal Fair Housing Act HUD guidance does suggest that denial of housing based upon gender identity could be sex discrimination. And I would expect that that guidance would be updated in the not too distant future as the other federal agencies have updated their guidance to include gender identity under the umbrella of sex discrimination. Jails, again, our counties and other municipalities may be running jails. Whether you run them directly or it's contracted to a private vendor to run them, the county or municipality will still be responsible for what happens there. Again, there's no specific requirement related to transgender employees, or inmates in prisons, except that the Prison Rape Elimination Act does prohibit jails and prisons from segregating transgendered individuals without their consent, unless there's some kind of court order or other reason that they must be segregated based upon their own personal safety. The other side of that, though, is that under the Constitution for cruel and unusual punishment, there would be a duty to protect, and under the PREA as well, to protect transgendered inmates from excessive violence and cruelty by other inmates because of their status. So there is a critical balancing act that must be done for those who operate prisons, because on one hand you can't exclude them or put them into an exclusionary position because of their transgendered status, but on the same time you have to try to protect them in the regular population, which may be difficult. So what do we do? When we're out, we should do this with regards to employment and other related in our public accommodations or service issues, but we should establish policies and protocols to address the appropriate responses should a transgender individual require service. So rather than wait until someone walks in the door that may make other people feel uncomfortable, we have something in place that says this is how we treat people that might be transgendered, and this is what we need to do. If we have public showers somewhere, do we have curtained areas where people can shower privately, for example? Are there ways to address these issues ahead of time so they don't become problematic in the moment because we haven't thought of them yet? You want to ensure that all staff is trained regarding their non-discrimination obligations, so that if a transgender individual walks in the door, they are not denied service in any way. If you have a transgendered individual that requests service, just like with employees, so if you have a resident of a nursing home, or you have an individual that is an inmate in a jail or is otherwise more of a constant service receiver for your organization, establish a dialogue with that person to determine what their wishes are. Do they want people to know what their status is? Some of the case law and guidance that came forward when I was researching this webinar was transgendered individuals in nursing homes that were very concerned about others finding out about their status because they didn't, they went into the home at the time that they were presenting in the gender that they had, but were afraid that others might find out their biological identity. So have those open conversations so that you know what to do and cannot, again, step on a landmine because you're assuming what the person might want you to do if conflicts arise. Address conflicts as confidentially and promptly as possible. So if you have a complaint by a customer about a transgendered individual, or, for example, if you're in a nursing home and it's a shared room situation and another resident finds out that they're with a transgendered resident and complains, you want to address this quickly and confidentially. And I would say, what do you do when conflicts arise in other populations? So in the nursing home situation, if two residents didn't get along that were in a room together, how would you address that conflict? It has nothing to do with transgendered status, that just has something to do with a resident that doesn't want to be in the same room with another. So you try to be as uniform as possible when addressing conflicts that are similar to other issues that come up. Otherwise, you may be considered discriminating against based upon transgendered status. So transitioning to schools for our last couple of minutes, and school districts are in a unique position among public sector entities because of the requirements of Title IX under the federal law, and because of the requirements of the Dignity for All Students Act, which prohibits bullying and harassment, among other things, based on transgendered status and gender identity. And that's a more of expansive definition of bullying than harassment would be, for example, for employers. But the path is similar as in employment-related guidance, and I know the State Education Department has issued guidance related to transgendered students, and frankly reads very similar to guidance that has been out for employers as well. The idea, what the guidance requires is that you have to respect the wishes of the student regarding their gender identity, and in most cases, the student's statement should normally be enough. Unless you have a significant reason for believing that the student is not being honest regarding their stated preferred identity, then you should not need more than what the student says to allow them to change what their identity is at school as far as their gender. You need to allow students to use the facilities of their identified gender. You need to maintain the confidentiality as much as possible. And the guidance here, they discuss FERPA, and generally FERPA allows you to share information within your organizations as schools for interagency communications, but the guidance does suggest that that FERPA exception only applies where there is a need to know, so that if a student's records identify them as a different biological gender than what they're presenting as, and that information is distributed to a wide breadth of staff in your schools, you may want to think about, does every individual that is told about this gender identity difference, do they really need to know? If a student comes, for example, transfers from another school, they're presenting as female even though they're all biologically male, and no one would know but for the fact that you told them, is there a real reason that every teacher in every classroom or that anybody else in the district actually needs to know that that student's biological gender is male? Also, you should allow the students to participate in programs based upon their gender, as opposed to their biological gender. So girls' sports, individuals that identify as female or as girls should be allowed to participate in the girls' sports, and the same with the boys' sports. The individuals, if I'm a female but I identify as male for my gender identity, I should be able to participate in the boys' sports. Now, what the state guidance does not help us with is what happens when the student's gender identity violates the wishes of the parents. And that's a significant issue that some of our clients have had to address, where students are identifying with their non-biological gender and the parents do not agree with the student's preference. And also, it doesn't help us really address issues where there's significant conflict with other parents, and this usually comes up obviously in locker room situations. And to the extent that you're able to do so, we would recommend that you try to set up your locker rooms in a way that would allow for privacy for all of the students that are involved. Having curtained areas for students to change, regardless of whether there's somebody that has a different transgender or not. Having that ahead of time, if you can manage it, sort of helps the situation if someone that's transgender comes in, because then you're not setting up something specifically to exclude that transgendered individual from the group, because it's already existing and it can already be used. But I think that this is going to continue to evolve over time. Again, even in the last 6 months, things have changed significantly, and so we'll try to keep you posted as much as possible. And I didn't see any questions while we were talking, but if there's anybody that has any questions they want to type in, we can stay for another minute or two. Otherwise, have a great afternoon and a great weekend.